A Supreme Court decision just dropped, and depending on how the next few months unfold, it could rattle California's carry framework faster than most people expect. But before adrenaline takes over, before headlines start flying, and before anyone changes how they carry, we need to slow this down. Because in the world of firearms law, 3 words decide everything: effective, paused, enforced. If you don't understand the difference between those 3, you can accidentally step into a felony, even while believing you're following the Constitution. Let's unpack this carefully, methodically, and without hype. Part 1. The moment everyone is talking about. At the center of the current shockwave is a ruling from the United States Court of Appeals for the Ninth Circuit. That court has jurisdiction over California and several other Western states. When it speaks on constitutional matters, state laws can shift. But here's the first critical lesson. A court opinion is not the same thing as a green light. Many people hear phrases like struck down, unconstitutional, major win, ban is dead, and they assume the law instantly disappears. That's not how the system works. There are 2 parallel realities in American law: the legal opinion world, the enforcement world. They overlap, but they are not identical. Part 2. The shadow of Bruen. To understand why this ruling matters, you have to step back to 2022 and the landmark decision in New York State Rifle and Pistol Association vs. Bruen. That Supreme Court case fundamentally changed how gun laws are evaluated. Before Bruen, courts often used what was called a balancing test. Judges would weigh government interest, public safety, individual rights. Bruen threw that out. Instead, the Supreme Court of the United States said, if a modern gun law restricts conduct covered by the Second Amendment, the government must prove that restriction is consistent with America's historical tradition of firearm regulation. That's a massive shift. Now states can't simply argue, we think this makes people safer. They must show historical analogs, often from the 1700s and 1800s. That's why you're seeing domino effects across the country, and California is right in the middle of it. Part 3. What the Ninth Circuit actually did. The Ninth Circuit's recent ruling called into question California's sweeping open carry prohibitions, especially in heavily populated counties. But here's the nuance. The court did not erase every firearm restriction. It did not create automatic open carry statewide. It did not eliminate permit requirements overnight. It did not guarantee police will stop enforcing existing statutes tomorrow morning. This is where the danger begins, because when a court rules against a law, the state can respond in several ways. Accept it, ask for rehearing, appeal upward, request a stay. That last word matters. Part 4. The power of a stay. A stay is essentially a judicial pause button. If a court issues a ruling but then grants a stay, the old law can continue to be enforced while the legal battle continues. So imagine this. A headline says, "Ban struck down." Social media celebrates. You adjust your carry behavior. Meanwhile, a stay has quietly kept enforcement active. You can still be arrested under the statute, and even if you ultimately win in court, the process becomes the punishment. Legal fees, gun seizure, court appearances, public records, employer consequences. Winning years later doesn't erase months of stress. Part 5. The enforcement reality. Here's a truth that surprises many people. Police officers enforce statutes, not news headlines. Unless there is a clear order instructing agencies to stop enforcement, officers often default to the written code. That's not a political statement, it's procedural reality. So when a ruling drops, departments typically consult county counsel, state attorneys, internal legal advisors. Until formal guidance changes, enforcement may remain exactly the same. This is the confusion window. And confusion windows are the most dangerous time to experiment. Part 6. The California carry. May's California firearms law is not one rule. It is a layered system. State statutes, county policies, permit conditions, sensitive place restrictions, school zone laws, federal overlays. When courts disturb one layer, the others do not automatically collapse. That's why I call it a maze, and mazes punish assumptions. Trap number 1. Carry is carry. Open carry and concealed carry are legally distinct. They can have different licensing structures, different location prohibitions, different penalty tiers. Winning an open carry challenge does not automatically legalize concealed carry everywhere. Trap number 2. My permit covers everything. A permit authorizes certain conduct. It does not immunize you from location-based violations. For example, government buildings, courthouses, airports, certain posted private property, each carries independent legal consequences. Trap number 3. If I'm right, I'll be treated like I'm right. Being correct on constitutional grounds does not prevent arrest during a transitional period. The courtroom decides constitutional validity. The officer decides probable cause. Two different thresholds. Part 7. The school zone. Example. Consider a hypothetical scenario. You possess a concealed carry permit. You remain in your vehicle while picking up your child from school. You never step onto campus. But school zone statutes often include measured perimeters. You may believe you're outside the restricted boundary. An officer might disagree. Now the issue isn't the Second Amendment. It becomes a dispute over feet property lines, geographic mapping. That's not a place you want to litigate from the back of a patrol car. Part 8. The 2026 question, private property defaults. One of the most consequential fights unfolding nationwide concerns, private property carry rules. There are two competing models. Default. Yes, you may carry, unless the property owner posts a prohibition or directly asks you to leave. Default, no. You may not carry unless the property owner explicitly grants permission. That difference transforms everyday life. Think about where you go daily. Grocery stores, gas stations, restaurants, shopping centers, parking lots. Most are private property. If the default flips to no, your right becomes a guessing game. And guessing games produce criminal exposure. States have experimented with both models. Courts will determine which aligns with constitutional history under the Bruen framework. 2026 could bring clarifying decisions that either cement restrictions or dismantle them. Part 9. Sensitive places and the death by zones. Strategy. Modern firearm restrictions rarely appear as total bans. Instead, states expand sensitive place categories. If every place becomes sensitive, practical carry shrinks dramatically. Courts are now wrestling with how far that concept can stretch. Does history support bans in parks, public transit, large events, entire downtown districts? The answers are still developing, and until those lines are drawn clearly, caution remains your strongest ally. Part 10. The 3 biggest mistakes right now. Mistake number 1. Treating social media as legal authority. Viral posts are not judicial orders. Always verify. Is there a stay? Has enforcement guidance changed? Has the mandate issued? Mistake number 2. Testing boundaries. During chaos. When a major ruling drops, some people rush to exercise new perceived freedoms. That's precisely when legal uncertainty is highest. Test cases are expensive, and they are permanent. Mistake number 3. Forgetting. Jurisdictional variations. Even within California, enforcement culture varies by county. Across state lines, reciprocity and statutory definitions shift immediately. Crossing a border can change legal status in seconds. Part 11. The discipline strategy. If you want a practical plan, here it is. 1. Separate law from status. Ask, is the ruling effective today? Is there a stay? Has the enforcement guidance changed? If uncertain, assume the old rule applies. 2. Keep your carry routine predictable. Boring is protective. Avoid sudden behavioral changes based on incomplete information. 3. Memorize high-risk categories. Know these cold. Schools, government buildings, courts, airports, posted private property. 4. Manage interactions carefully. In encounters with law enforcement, stay calm, follow instructions, avoid volunteering unnecessary details, seek legal counsel if escalation occurs. 5. Track changes. Systematically choose one or two reliable sources for updates. Do not rely solely on algorithm-driven feeds. Part 12. The emotional reality. Many responsible gun owners feel exhausted. Rules change, litigation continues, definitions shift. But frustration does not protect you in court. Discipline does. The Constitution may be evolving through litigation, but your immediate responsibility is compliance with enforceable law today. Final takeaway. California's carry framework is under significant judicial pressure. The ripple effects from Bruen continue moving through the lower courts, including the Ninth Circuit. But remember this: a ruling is not the same thing as immunity. A headline is not the same thing as legal protection. Excitement is not a defense. Before you change how you carry, confirm: is the decision effective? Is enforcement paused? Has guidance changed? Because protecting your rights starts with protecting your record. Final note: this is educational information, not legal advice. Laws evolve. Court orders can be stayed. Your specific facts matter. If you need guidance for your particular situation, consult a qualified firearms attorney licensed in your jurisdiction. Stay informed, stay disciplined, stay lawful.